mistake, and I'm sorry. And if I do get out, or when I get out, I'll store community corrections phone number in my phone. When I wake up every day for my kids to go to school, I'll make sure I call first thing in the morning. I'll quit smoking weed. I'm sorry, but if I'm in here any longer, I'm gonna lose everything. My 401k, my health benefits. I need to get back to my kids. I miss them. They miss me. They don't even know I'm in jail. I told them I was on vacation because I don't want them to know.
Why'd you do this? I don't.
Sorry.
But why?
And Your Honor, that is my understanding of where we are today in its entirety. And Ms. Fong-Fachan admits to all of those things. She did go into custody. She placed upwards of 120 to 130 phone calls, one of which was to a podcast. And I think that demonstrates to the court that her statements that she learned her lesson in custody, it may hinder that because Ms. Fong-Fachan was laughing, joking on a podcast.
Oh, yeah, she was. She thought it was all a game.
Of course.
And guess what? You can think it's a game. It's a game with me that you will never win. I'm amazed that you took something that was a misdemeanor. I don't want to call it a simple misdemeanor, but a misdemeanor. And something that more than likely you would have never spent any time in jail on. And somehow on the date of that offense, parlayed that into a felony charge, or at least a high court misdemeanor charge. I don't even understand how that happened. I don't know. Yeah. Court does call the case. People of State of Michigan versus Julie Van. Oh.
Good afternoon, Your Honor. Warren Green on behalf of Ms. Fong-Fachan. State name.
Julie Fong-Fachan.
Your Honor, today's for a motion hearing before the court is the defendant's motion to modify bond. Our motion is based on MCR 6.106. Your Honor, when we filed this motion, it wasn't our intent to try to distort the law or the facts to make an argument that somehow the court is bound to reduce her bond or grant her request. I think we know what the facts are leading up to this, and we know what the law is on whether the court can deny bond in such an instance. What we did was we laid out what we felt was a full and fair account of the actions leading up to this. And I don't think the people denied any of those actions leading up to this, just from a purely scheduling standpoint and from the standpoint of Ms. Fong-Fachan's bond violations. What I wanted to draw the court's attention to was that prior to Ms. Fong-Fachan's engagement with the criminal justice system in this case, she had previously engaged in behavioral health counseling. She was going to Apex Behavioral Health in Westland. I included the date in our motion. I mean, the address in our motion, but she was doing that until January of 2023. The way Ms. Fong-Fachan described that to me was, you know, I think some of the behavior the court has seen through the bond violations it's heard is that Ms. Fong-Fachan, for some reason, you know, when confronted with an issue in her life, at first blush, her first reaction is maybe to be dishonest or wiggle out of a situation. And I think she sought help with that exact behavior before. So our primary argument in support of the court granting our motion would be so that Ms. Fong-Fachan could re-engage with that kind of counseling. Of course, Ms. Fong-Fachan is fully aware of what her bond conditions were and will remain fully aware of what those are if the court does grant our request. Ms. Fong-Fachan will or cease using any intoxicating substance during the pendency of this case. I know she wants to seek reemployment for the job that she lost as a result of her actions. And I think she acknowledges that the delay and the turbulent bond release she's had so far have been her own doing. I think the time she spent in custody, she's had an opportunity to reflect and to think about how she wants to move forward. I think she wants to head in a positive manner towards resolving this case, and we would be asking the sentencing court to consider probation still. She knows that her bond violations are going to be considered by the sentencing court in determining sentence at the resolution of this case. So, Your Honor, what we're asking the court to do is reinstate her previous bond. We're asking the court to keep the previous bond conditions in full force and effect, and that the court modify her bond such that she be fitted with a scram alcohol tether prior to her release if the court grants our request.
Is there anything additional from the people?
The opportunity to review the counsel's motion and file a response to counsel is correct. I did not deny any of the allegations in there. The only additional information that I did include was my knowledge of the defendant's CPS case regarding her children. But at this point, I would leave her current status at the court's discretion. Thank you.
Is there anything you want to say to me?
I just want to say thank you for allowing me to have a motion hearing.
Tell me why I should let you out. Because, and there's a reason why I'm asking this, and so it's clear. You know, and the facts of the case were relayed to me last hearing that we were on, or the alleged facts, I should say. I'm amazed that you took something that was a misdemeanor. I don't want to call it a simple misdemeanor, but a misdemeanor. And something that more than likely you would have never spent any time in jail on. And somehow on the date of that offense, parlayed that into a felony charge, or at least a high court misdemeanor charge. I don't even understand how that happened. But even after you did that, you didn't have a case that you still wouldn't have spent any time in jail for. And all you had to do is just follow the rules. That's all you had to do. And then somehow or another, you've now spent 3 weeks in jail on something that you would have spent no time on whatsoever. And I don't get it. I really don't. I say all of that to say, I feel like this is almost Groundhog Day. I bring you back the first time after the first week, gonna let you out, find out what you've done while you've been in jail, can't let you out. You spend that second week. Then I come back the second week, I let you out. Don't make it a day before you broke the bond conditions. Then next thing you know, next time you come back in, I got to throw you back in. And now here I am again. So it almost is that old saying, why should I repeat and do the same thing? Because that would be insanity on my part. Tell me why it wouldn't be. You tell me why I should take a chance on you.
I had some time to sit down and think for these past few weeks. I won't do it again.
You lost your job. You missed your kid's birthday. For what?
For my actions.
Did we print off that communication I received?
No, but I can't.
Council, I received an email, which I'll just widely to print out. I actually meant to have a copy here, and that's my fault, so that you could have that from, I guess, the father of their children, their partner. I don't know if you've seen that, whether that was sent.
Yeah, Your Honor. Yes, I did. Yes, I did, Your Honor.
Anything you want to say regarding that?
Your Honor, I do appreciate Mr. Gray's kind words about my client. I think one issue that Ms. Fong-Fichan has dealt with for probably her whole life, but at least since I've come to know her, is that she has a remarkably difficult time kind of opening up and
Doing what?
opening up to people. And I think that's one of the reasons she was engaged in counseling before, was that it has taken us a long time to kind of develop an attorney-client relationship, just because there's something in Ms. Fong-Fichan's past, I'm not sure what it is specifically, that has created a situation in Ms. Fong-Fichan's life that she just has a difficult time kind of opening up and being truthful about what's going on with her, what her feelings are. And so I think the sentiments reflected here by Mr. Gray, who is presumably someone that Ms. Fong-Fichan has opened up to, probably give a more accurate picture of who she truly is than I can give to the court, or that even Ms. Fong-Fichan can provide to the court herself.
Have you gone through with her what her bond conditions are, counsel?
Your Honor, I have, and I believe that the bond conditions that previously existed are clear to Ms. Fong-Fichan now, but I would give her an opportunity here on the record to ask if she needs any clarifications or additional explanation about what the terms of bond are.
No,
Are you certain?
sure.
Okay. And you understand that there has been no modification to the previously instated no contact order that allowed for limited contact with Mr. Gray for purposes of raising your children by a text message. You understand that?
Yes.
Okay. Your Honor, something the court would, based on this correspondence, consider modifying today?
Modifying what?
The no contact order that was previously in place between my client and Mr. Gray?
No, I'm not, I'm not gonna do that. I mean, and here's my reason. I'm not trying to be harsh about it, but that condition was in place from the get-go, right? And, I think I indicated this to you, counsel, that when she came back and there were all those calls, I think I told you, because the communication regarding children was supposed to take place by text message, that I could even forgive a couple calls a day. I would just, without even knowing the content, I would just have to say she can't have that form of commitment. But that's not even what happened. I mean, she didn't, it's not even just about not following the rules. It's like she wants to play by her own rules. And I hope she understands this is what you get when you play by your own rules and they come in contravention to the court rules. This is what you get. So I'm not going to change anything. I just want her to follow what was originally set. Just do that and I can be happy.
Understood, Your Honor.
And don't say you don't know. Don't say, I didn't know I couldn't drink. You've got an attorney. You can ask your attorney, can I do this? After I threw you in jail for 2 weeks, it would seem to me that the first thing I would have asked my attorney on getting out or before is, what can I not do? But you didn't do that. That next day you were drinking. Do you still have a job even?
No,
So what are you going to do?
I don't have a job. Like, I lost my job, but on the weekends, I throw a party on Saturdays.
Your Honor, I think what Ms. Bonfachan means to say is she was in the business of
Pardon?
promoting events and parties.
I know, and that becomes a problem because you just made this a mess.
Your Honor, I think if she's on a scram tether, she would refrain from partaking in any activities that would violate court's orders. She would, of course, still be subject to the drug testing requirement that was previously in place. I understand that in fire.
But these things are promoted on the internet.
They are.
And one of the conditions I was going to have is that she can't appear vocal, oral, or otherwise on the internet. So how's she do what she was doing without doing that?
Ms. Fong-Fichan, is it possible for you to continue the business you're in without using Instagram or other social media as a way to promote your business?
I guess I just have to stop.
Okay. But is it possible for you to continue your promoting business without using social media?
And that's how we promote the party. So,
Okay.
no.
Oh, dear God.
Are you able to seek other employment or
I'll
reemployment at
look
your
for another
previous
job.
job?
I'll look for
Okay.
another job.
Are you able to get in contact with your union representative at the University of Michigan to see if there are ways that you can seek reemployment where you previously were working?
Possibly.
Okay.
You know, ma'am. Frankly, for the most part, had you gone on social media after being in court, I could have cared less. But it's what you did when you went on.
Understand?
Well, what was in your head to call for the Washington County Jail? Really, what?
I don't know.
What? No, you had to have. Don't tell me I don't know. What the heck were you thinking? Have you heard yourself on that podcast when you call from the jail?
I haven't. I heard one clip, but I haven't watched it.
Stupidest thing ever. I'm gonna tell you what, man. You better thank that man standing next to you. Because I'm gonna be absolutely honest with you. The way I am, if you had, I'd be so done. And you just wouldn't see the light of day if it weren't for what arguments he was giving me. And at least the faith and hope that he has in you that you can just do the right thing for once. He has that faith. I'm not sure I do. But he's convinced me. I'm going to give you another shot. God help me if you had come back. God help you. Because I don't know who's going to. I'll reduce the defendant's bond to a $25,000 personal recognizance bond. I'm going to add all previous conditions that were originally set are reinstated. You understand that?
Yes, Your Honor. Thank you.
There's to be no appearance, or vocal, oral, or otherwise on any social media platform. Defendant is to be placed on a scram tether prior to release. All right. Now let me explain something. You know about the scram tether?
I just know not to drink alcohol.
Yeah, I think we figured that one out. Right? Now, if it comes back and you violate, so the reason I'm not just putting you on a sober link where you have to blow is because you don't know how to follow any rules. And that requires blowing 3 times a day. And I know darn well before the week is ended, you will not have done that because you just can't. At some point, you get so stubborn and you just say, I'm not going to blow into this thing. And then we're back here. So I'm trying to avoid that. If it comes back with anything, consumption of alcohol, I'll listen to you, but it's going to be really hard to convince me you didn't do it. Am I understood?
Yes.
Please, let's see if we can just make it to the 23rd without any further incident.
The 23rd. Our absolute best, Your Honor.
The what?
We assure the court we will.
I will.
There will be no issues of bond on 423 is what Ms. Bonfachon.
I've heard that 3 times before. Thank you. You thought I would? I was going.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.